afternoon. Uh, Thank you for joining us for Workplace Investigations, today sponsored by the Workforce Development Board of Ventura County. My name is Anna Manzano. I'm the Digital Media and Event Strategist here at the California Employers Association. Before I kick it off to Eli with today's content, just a couple details to go over with you. So as you see, your audio is going to be muted throughout today's presentation, but as you're already doing so in the chat, there will be lots of opportunities to engage during today's session. One of the ways will be asking your questions. So if you have any questions, the best way to get those answered in a timely and organized fashion is to head over to the Q&A box. If you're on a desktop, it's along the bottom with the two bubbles, this Q&A. As Eli is delivering the content, we are fortunate to have Juliana, our HR Compliance Director, who will be managing the Q&A for us. And we'll try to address those as we go to make sure all your questions get answered today. Handouts, those were sent out in yesterday's reminder email. However, I know we did have a lot of final registrations rolling in. So what I'm going to do is pop that PDF into the chat box in just a minute. Once you see that file pop up, if you just click on it, it'll download locally to your drive. And feel free to message me if you have any issues with accessing that file. And then last but not least, we do have a survey. Because your feedback is incredibly important to us, we have put together a simple survey. It's 5 questions, takes about 60 to 90 seconds max to complete. But the feedback that you share with us, we then share with our partners over at Ventura County, and we just collectively make sure that we are providing you with the best resources possible to run your teams and your companies with peace of mind. So if you could take a minute at the end, we would really appreciate that help. So as I mentioned, today's training is sponsored by our partners at Ventura County. And today we are so happy to have Rebecca Tafoya, who is the Business Solutions Specialist, to share more about resources available to you.
Thank you so much, Anna. Thank you so much for the warm introduction. Hello, everybody. My name is Rebecca Tafoya. I'm a Business Solutions Specialist with the Workforce Development Board of Ventura County. And I just wanted to remind everybody in regards to our complimentary human resources hotline. It's available at no cost. You can call the number between 8 to 5, Monday through Friday, and you should have someone there live ready to answer any questions that you might have. If it's in regards to hiring and firing processes, paid sick leave, harassment, anything related to the job, on the job, as well as remote workers, you can call and there'll be somebody to answer any questions that you may have. Also, just if anyone's interested, the Business Solutions team within the county works on a lot of different business needs, whether it be hiring events, job fairs, employee on-the-job training opportunities. You can definitely give me a call and I'd be happy to assist you with any of those needs. And then, so back to the California Employers Association, and they will be introducing investigating workplace problems. Thank you so much.
Awesome. Thank you, Rebecca, Cynthia, Colleen, the entire team behind the scenes over at Ventura for getting everyone gathered today. And so now I have the privilege of introducing our trainer. We have Eli Nunez, who is one of our awesome HR directors. And I know we have so much to cover, so it's all yours, Eli.
Thank you, Anna. Thank you, Rebecca. If you have any questions, of course, please put them in the Q&A box, or Juliana will be lurking about, ready to answer them. A little bit more about us. We are California Employers Association, and our goal is to provide you, as callers, with peace of mind. What we provide is, timely answers, quick responses, as well as trainings and webinars such as the one you're on today. We also create fact sheets and other forms for our members to use, in addition to other trainings and consultation on workplace issues. So it sounds like we do a lot, but one thing that we are not, one thing I definitely am not, is I am not a lawyer. And even though we do have people on our team with legal experience, this training is for educational purposes, not to be taken as legal advice. We do not dispense legal advice. If you have any questions of a legal nature, we always recommend that you consult legal counsel with them. So now that we got the fine print out of the way, we'll jump right into the presentation. Have quite a bit of material to cover today, so let's get right to it. Some of the things we'll be talking about today, give you an overview on investigations and the requirements that come along with them. Some investigation triggers, in other words, in the workplace, when certain things come up, how do you know when you have to investigate? We'll talk about that as well, along with selecting the investigator. Who is the right person to drive that investigation, to go forward with it? Is it somebody internal, somebody external? we'll talk about the different things that play into that. How to plan your investigation from beginning all the way through. That includes things like witness interviews, reaching a conclusion, and finally, if necessary, taking prompt corrective action. All very important steps in the process to make sure that you stay compliant with the law and basically keeps you out of trouble, which is our goal, right? Make sure that we're doing things in a way that is not going to get us in trouble. So with that, let's talk a little bit about investigations as a whole. And workplace investigations are basically overseen, or we get guidance by FEHA, the California Fair Employment and Housing Act. So basically what this tells us is that as employers, we should take all reasonable steps to prevent and promptly correct any conduct that goes contrary to California guidance or California law. Now, one very important thing to keep in mind is in the state of California, the the state believes that if an employer knew or should have known that there was some harassment, discrimination, retaliation, or any other kind of legal action going on, then the company itself can be found to blame for it. So what this means is that if you have supervisors, leads, foremen, whatever it is, that become aware of a problem and either don't escalate it to you, decide to sweep it under the rug, or try to handle it themselves without letting anybody else know and fail at it, then it is not just them that are responsible. The organization as a whole can be found responsible for the situation. In other words, if one of those supervisors or managers knew about it, then in the eyes of the state of California, management, ownership, whatever it is, the whole organization knew or should have known that it was going on. So that's why it makes it so important to train all your supervisors, anybody that's in a leadership position, all the way down the line to make sure they know how to handle these things. Now, some of the things to keep in mind when you're conducting an investigation, it should be done in a timely manner. And of course, when we're investigating something, we should be thorough as necessary for it, and be objective. In other words, we're not going to be guided by our feelings, by our gut. We're looking for facts in the investigation. If there are allegations against somebody, we want to make sure that they have the opportunity to respond to these allegations. In other words, we're not just looking to build up, a preponderance of evidence or a bunch of evidence to push somebody out the door without giving them a chance to respond. Anytime somebody's accused, you want to make sure they have the opportunity to respond to the allegations. Now, at the conclusion of our investigation, we have to make sure that anything we come up with is supported by evidence, and if it's necessary to take corrective action to correct the issue or to address it, we want to make sure that this is done promptly and appropriately. In other words, if you have hopefully policies and procedures that guide you in that way, we want to make sure we stick to them every time. We want to make sure that we're consistent with that. Something else to keep in mind when we're talking about investigations and is to make sure that no retaliation takes place against the person that is raising a complaint or raising that issue. In other words, as an employer, you can't discipline, demote, terminate, basically take any negative action against an employee because they reported an incident or participated in an investigation. I would like to say when we talk about this, if you think about the old days, what would happen when an employee raised a concern, raised an issue, be it against the organization or against a manager or supervisor? Unfortunately, a lot of times that employee would find themselves pushed out the door. Well, the state of California was aware of this, and that's why we have these retaliation protections now to make sure that if something was brought up by an employee, they are protected from being retaliated against for bringing it up. Of course, in order for these protections to be valid, uh, the employee has to have a reasonable and good faith belief that there was an unlawful act or a policy violation. So in other words, if the employee is just accusing somebody else because they don't like them or because, out of spite or to get even or any reason that's not in good faith, then technically that is not really protected as far as retaliation, right? You could say, well, they're lying, they're accusing this person because, they were suspended or whatever other reason. So again, as long as the accusation is reasonable and in good faith, the employee is protected against any kind of retaliation. Now, as managers or supervisors or owners, whichever it is, we have to understand that our role in helping our organization is very important, especially when it comes to investigations or dealing with any kind of issues. So some of the things that could go wrong or that can really escalate if we don't address these things immediately is obviously the first thing is the employee can go to any kind of federal or state agency, be it the EEOC or the Civil Rights Department, especially if we're not addressing things in a timely manner or we're ignoring things. Other than that, we could be looking at private lawsuits by employees on top of other damages to our organization. So if we're not addressing these issues head on, if we're not correcting them as they go along, you can get things like bad publicity, a toxic work environment, which leads to turnover, lower morale, low productivity, all kinds of things. And I think at one time or another, most of us have had that kind of experience at work where it is just not a good environment, whether it's because of the people that were working with us, the people that were managing us, or whatever it is. And if nobody does anything to correct that, ultimately, it's going to lead to us leaving or other people leaving or just make the workplace very intolerable. The other thing to keep in mind too is when we talk about discrimination or harassment, it's not just dealing with our current employees. This can also be something that can affect applicants, outside parties that come in, anything like that. And these are all things that should be investigated whenever it is brought to our attention. And finally, I mentioned earlier, training is so important for all of our supervisors, anybody in the management position, because really, the way that supervisors or managers, foremen, leads, whatever you want to call them, treat their subordinates is basically going to create a pattern to how coworkers interact with each other. Example I always give is I have kids at home, and no matter how many times I say, do as I say, not as I do, they're still going to mimic every single bad behavior that I show. Well, when you talk about supervisor and subordinates, same thing happened. Supervisors can talk about policies and procedures and the rules as much as they want, but if they're observed by their subordinates breaking those rules or breaking those policies, chances are the subordinate's going to mimic that behavior and do it as well. So again, training is so important, making sure that everybody in the organization is walking that talk. So let's talk about how we manage those workplace investigations. The first thing we need to do is know how to spot the issues, how to identify when we have to do anything, right? How do we identify appropriate and inappropriate behaviors? So the important thing is, it's very easy to think that we just have to deal with those negative things and the good things will happen by themselves, right? The old carrot and the stick. Well, it's very important too, to make sure that we're recognizing, spotlighting those good behaviors, giving the rest of the team something to strive for, something to mimic along the way. Another thing we can use when it comes to time to manage, our behaviors, our workforce is respect, making sure that we are promoting an open environment where different perspectives, different ideas are at least heard, respected, where everybody feels comfortable voicing whatever is on their mind, right? Whatever their opinion is. That can include things like having an open door policy where employees can come and tell you their concerns or their ideas, or ways for them to report any issues that are going on out there. And finally, managers, owners, everybody, it's our responsibility to make sure that we are creating a work environment that's free from harassment or free from any kind of those activities. So easiest way to do that, of course, is anytime there's a claim, anytime there's an issue that's brought to our attention, respond to it immediately, whether it's triggering an investigation right away, following through with anything we need to, make sure that we are responding in a efficient and quick manner. Now, I've mentioned a few times, harassment, discrimination, retaliation. These are all things that the state tells us obviously are against the law, but just as important for employers is investigating any claims of policy violations. And as you know, sometimes your policies, your company policies, aren't necessarily as dictated by state law, right? The state tells us harassment's, illegal, discrimination, retaliation, that sort of thing. But you could have other policies in your organization that you want to make sure that you're enforcing and investigating as well. Things like bullying or workplace violence, fraud, or misconduct. All of these should be investigated to see if we have to conduct a full written investigation under FEHA guidelines as well. And the thing about this is, if you see these examples when it comes to bullying or workplace violence, it's important to dig into it to try to find the reason behind it, right? If you have workplace violence, it's just because the participants in it were cheering for different sports teams, or they accidentally bumped into each other in the lunchroom, or somebody stole somebody else's lunch? Or is it because of somebody's religion or somebody's race, somebody's sexual orientation, that sort of thing? Anything that's protected by law. So that's why it's important to not just say, well, it's just workplace violence and dismiss it as that. It's important to investigate, look a little further to see if there's any reasons behind it that would prompt a more thorough, extensive investigation, as well as different sort of actions to protect our employees and protect our organization. So let me give you a couple examples that you may have encountered in your workplace in the past. The first one is the old hostile work environment example, right? So in this case, we have an employee complaining of a hostile work environment. Goes into your office, says, there's a hostile work environment going on. I want to complain about it. Once you dig a little further into it, the employee says you have a supervisor that's strict about employee attendance. They write everybody up. They're making the hostile work environment because, if anybody's late, they write them up. Well, first step you do, go in there, check the timesheets, talk to the supervisor about attendance issues. And if you confirm that, that supervisor's strict across the board, treats everybody the same, writes everybody up if they're late, you can safely conclude there's no policy violations at that point. Sometimes you just have a supervisor that really believes in the letter of the law and wants to enforce the policies, you know, down to the wire, and that's fine. But as long as they do it consistently and evenly across the board. And the thing to keep in mind too is sometimes employees, will come up with a complaint or come up and complain to us and start throwing these terms at us, right? Hostile work environment. I'm being discriminated against, I'm being harassed, that sort of thing. That's why it's important to ask follow-up questions, find out what's really going on, and do your investigation to see if that really is an issue. As we'll see in scenario 2, this is similar to the first one with a few key differences. So in this one, again, we have an employee complaining of a hostile work environment. And when you ask a few more questions, you find that the supervisor is strict about attendance, but only for certain employees. Now, the employee is claiming that the supervisor favors male coworkers and allows them to miss work or show up late, but only punishes the female coworkers. Once we get that allegation, that raises the issue of possible gender discrimination. So in this case, again, we're going to go back and check timesheets. We're going to go investigate a little further because, again, the allegations of harassment, discrimination, retaliation, and they're giving us a pattern. They're letting us know what's going on. So that would trigger, a little bit more serious investigation at this point. Again, if it's a policy violation, we're going to investigate anyways, but once we're dealing with discrimination or harassment of any kind, we want to make sure that we're digging into it, getting to the bottom of it. So the Civil Rights Department, of course, provides us with a workplace harassment prevention guide that's very useful. Got a little bit.ly link there for you if you want to follow that along. It tells you kind of what we can do to prevent harassment in the workplace. Very, very helpful. So now in the beginning, I mentioned some investigation triggers. In other words, some things that should trigger an investigation for you as a supervisor or a manager. And this is a great graphic, probably one of my favorite graphics that we have. And I always recommend, if you're a new supervisor, a new manager, take a screenshot of this, print it up, put it up in your office because this will remind you of when you should be looking into things. First one, quite easy. Whenever you have an employee complaint, whether it's formal, in other words, a formal written complaint, informal, that somebody just mentions it to you in passing, or an anonymous complaint, that is a trigger that we should look into things because if that complaint is made, again, in the eyes of the state, the company knew or should have known that something was going on because the complaint was made. The other one is suspicion. If you have suspicion that someone's violating company rules or expectations, that is enough for you to at least look into it a little further. Now, as managers, we know our workforce. So we know when something feels a little bit off or something feels like it's not going quite right or something else going on. So in those scenarios, it's best practice to look into a little further, see what's going on. Next one, also very obvious, observed conduct. If you observe somebody violating company policy, yelling at somebody, bullying somebody, harassing somebody, obviously that's a clear trigger to look into it. Former employees are another one. And this happens sometimes at termination. We go to separate employment with somebody, and on their way out the door, they let us know that, hey, just so you know, so and so out there's, harassing people, or so and so, hit me one time or smacked my bottom as I was walking by or whatever. I mean, our initial thought may be to ignore that because, it's a person we're letting go. They're probably just mad. They're probably just throwing things out there. However, that doesn't mean that we should not look into it. We should always look into those complaints, even if they're raised by former employees. If it's somebody that we're terminating at the time or somebody we terminated a week or a year ago, if that complaint is brought to us by them, let's look into it. Now, those administrative triggers, these are the ones that always ruin our Monday mornings as HR. It's when we walk into the office, there's a stack of letters there, and we have a letter from a lawyer's office or from the state that's requesting additional information from us, whether it's copies of employee files or, payroll records or whatever it is. Because once we get that letter, we know that complaint's been made and the wheels are already in motion. So as soon as we get that notification, it's time to start looking into things, see what happened, see what's going on, see what we have to do to address or correct that issue. Next is any unexplained changes in the workplace, behavior, your employees' attendance changes, morale, that sort of thing. One good example is if you have a group of employees that always sits together at break time, lunchtime, or whatever it is, and all of a sudden you notice that one person just separates themselves from the group. They always used to hang out together, and all of a sudden they're just want nothing to do with them. They don't talk to them. That's your clue that something happened there. Could be something quite innocent. Maybe they had a disagreement over you know, sports, a ball game or something else, and doesn't hurt to ask the question, hey, what's going on? Everything okay? Because you never know if maybe an inappropriate comment was made, some kind of physical, aggression was made or anything that the person just hasn't reported yet. So again, if you see those unexplained changes in the workplace, make sure we're looking into it. And finally, any gossip and rumors. Always good to have our ears to the ground, see what's going on out there. And if something's persistent, something keeps coming to our attention, either against a person or about a person, again, at least start asking the questions, start digging into a little bit, see what's going on out there. See if it really is just gossip and rumors, or see if there's a little more to it that is causing that. Right. Another example for you. In this case, we have a bar scene. And we know, obviously, bars, restaurants, that sort of thing, have a little bit possibly different culture. Anybody that's worked in those workplaces, and those things tend to be a little different. So in this case, we have a shift supervisor that knows that his employees usually talk about how attractive a customer is or isn't. So basically, they rate the customers when they come in. Now, when this happens, he noticed one of his employees kind of gets a funny look and pulls away from the group. So question is, in this case, what should Harold do? I have a few options for you if you want to throw an answer there in the chat for me. One, do you think this is just friendly, innocent interaction among coworkers and he doesn't have to do anything? Or do you think when this happens, you should go up to Randy in front of the other employees and tell him to lighten up and remind him that he works at a bar? Or do you think C, Harold should find the time to talk privately with Randy about what's going on and see if there's any discomfort or for his behavior? See some answers pouring in, and they're overwhelmingly C's, which tells me, your guys' head is in the right place here. That is absolutely the correct answer in this case, C. Yep, because the manager or supervisor has noticed Randy's reaction, right? Randy hasn't made a formal complaint, hasn't told him anything, but he notices something is off when that happens. So, yeah, I mean, having that private conversation with Randy about what's going on is definitely important. If Randy's behavior or is uncomfortable behavior, at the very least, the manager can dig a little deeper, see if there's any violations in the company harassment policy, right? Maybe the language being used is inappropriate. I mean, at the very least, speaking about customers or patrons that way, that's probably a dangerous practice if anybody overhears or anybody, becomes offended by it. It could definitely damage the institution. So again, be very careful about that. And, at the very least, Harold can also talk to his employees about how they're making the comments they're making, about not being as outspoken, if you will, about their customers' looks or customers' appearance. Now, when it comes time to when an employee gives you a direct complaint, say an employee walks into your office or gives you something in writing, that is a direct employee complaint about a behavior, something that's going on. It's very important how we react to it. And thing to keep in mind is, it's not easy all the time for those employees to submit these complaints, right? Remember the history. I mean, back in the day, if you complained about something that was going on, chances are it could blow back on you, right? Whether it was you'd lose your job or the rest of your team would turn against you or whatever it is. So it's not an easy thing to do. So here's just some sample responses, how we're going to respond when an employee comes with a complaint to us. Thank you for coming forward. I know this isn't easy, or I want you to know the company takes all harassment complaints very seriously and will start an investigation immediately. Just something that you're acknowledging the difficulty that it took for the employer to bring that forward and reassuring them that you are going to follow the policy, your company policy, in addressing these things. When it comes time to addressing it too, I mean, one of the common questions we get is, how soon do I have to address it? What's the timeline for it? And all the state tells us is, some complaints require immediate attention. Doesn't give us a timeline. Doesn't tell us that, within half an hour you have to do this, within 2 days you have to do that or whatever. But best practice is, begin that investigation within 48 hours. As far as when do you wrap it up? In a timely manner. I know it's a pretty broad statement, but again, I don't want to give you a time that says you have to wrap it up within a week, because sometimes these investigations take a little longer because maybe somebody is on vacation that you have to talk to, or somebody's out of town, or it's just maybe the scope of it is just so big that it takes a little longer than that 1 week or 2 week period. So again, we're going to aim for wrapping it up within 2 weeks. Keep those, guidelines fairly flexible, move them as you need to. Again, we're not going to cut our investigation short because we butt up against our timeline or against our self-imposed limit. If there's more facts to be sought out or more questions to be made, we're going to pursue those. A couple frequently asked questions for you. One of my employees just told me another employee said something that really upset her. I told her I was really disappointed that her coworker would say such a thing, and I told her that her coworker would be disciplined for saying that to her. Was that the right thing to say? Again, it feels like the right thing to say because it feels like we're comforting that employee. But again, we may be setting unrealistic expectations. So we want to have a supportive yet neutral response. You don't assume that what they're telling you is accurate. You don't basically give the impression that the other person will be punished before you conduct an investigation. So a better answer may be, thank you very much for bringing that to my attention. I'm going to look into it. We have a policy against any kind of bullying or any kind of language. So we're going to look into it and follow company policy in resolving this issue. Next one is, when it comes to timing. I mean, if as a manager you hear a comment made or something made about possible harassment incident and you have inventory coming up, so you have a busy week coming up, can you put that investigation on hold? And of course, you probably know the answer to this one is no. We're not going to put investigations on hold because it's inventory or because, we have vacation coming up or whatever it is. Maybe we have to delegate to somebody else. Maybe we have to bring in somebody else to conduct that investigation, but we're never going to put it on hold because it's inconvenient, especially when it's like a harassment discrimination investigation. We want to make sure that we're addressing these in a timely manner. Now, I mentioned delegating that investigation too. So this goes with, how do we choose who conducts that investigation? And obviously having somebody in-house investigate is going to be the most cost-effective way to address it, right? Whether it's an HR person, a member of management, if you have legal counsel on the staff, they may be able to handle that investigation for you. But it's important, to know what the person's authority is to handle the complaints. And of course, they have to be familiar with your company policy and any legal requirements. So, state of California tells us that for an investigation to be admissible in court, the in-house employee who conducts it has to be trained and qualified to do it. In other words, you can't just draft one of your coworkers' name out of the hat and tell them, "Hey, go investigate this for us. You're the man today." Nope, it's got to be somebody that has training and is qualified to do it. And in some cases, you can conduct the training in-house and have somebody from outside come in with assistance. So for instance, at CEA, we do that all the time where a company is conducting an internal investigation and they call us in as well to help with it. So we sit in there with the investigator, help with the questioning, help with the whole process, that sort of thing. The other option is selecting a third party or an outside investigator. And in some cases, this may be necessary. For instance, if the person that the allegations against is the owner or the general manager or the CEO, obviously having somebody internal conduct the investigation could be a little difficult, especially if they are, you know, report directly to them or below that person in the org chart. So in order for to be able to get an independent third-party investigator, they either have to be a licensed attorney or a licensed private investigator. And if you don't have any attorneys that you work for, legal counsel or investigators, you go on to employers.org, our website. We have plenty of partners that are licensed attorneys that can conduct that investigation for you from start to finish. Now, going back to, if you're going to conduct this investigation internally, if you're the one doing it, there's a few things to ask yourself before you actually start. Is there any biases that would interfere? In other words, the person that was accused, are they somebody that you've had issues yourself with before? Or maybe is it somebody that you're close with? Is it your best friend? Is it your in-law, your brother or sister-in-law, that sort of thing? And even if there is any bias, take a step back. You know, well, the fact that you're investigating this, even if you do everything correctly, if that person is close to you or related to you, is it still going to give the perception of bias? Because remember, sometimes it's not about what you do, it's about what is perceived. So again, take that step back and see how that investigation is going to be perceived. Same thing happens when you're investigating your boss or somebody above you, If you come up with a conclusion, is that conclusion going to be perceived as being overly lenient or overly hard against them because of their position with the organization? And finally, is there any special expertise that's needed for the investigation that you don't possess? If any of these are the case, then maybe that's when you start looking outside or to bring in outside help to conduct that investigation. Now, when it comes time to plan that investigation, some things to keep in mind is, are there any temporary personnel changes necessary? We'll talk about those and why they may be important. Talk about, gathering evidence, how you go about that. And finally, those witness questions. Is there anything in particular you should be asking when you're moving along with that investigation? So first one is when we talk about any kind of personnel or any kind of administrative changes to make in the meantime. And, the things to consider for these is somebody in danger? So has there been, a threat made against somebody, any kind of violence committed against somebody? The other thing to consider is the complainant highly emotional? When they come in and say, I can't work with this person, I can't even see them. I don't, if I see them, I start to shake or start to cry or whatever. That could be a reason to take some interim action. Now, again, you have to consider, should we change the reporting assignment for the time being, right? In other words, if an employee is alleging something against their supervisor, is it necessary to make some kind of change there so they're not reporting to them? Whether it's putting somebody in between them so they don't report to them immediately, or a temporary change at that point. Now, if you are going to make a temporary change, though, whether it's moving somebody from one shift to another or one team to another, be very careful, because if you do make a change and it affects the person that raised the concern, the person that made the allegation, then there could be the perception that they are being retaliated against for making that allegation. In other words, say you have a manager on the day shift that is accused by an employee of doing something, and you decide, well, just so they have to deal with it, we're going to move the employee to the night shift. They're going to work graveyard so they don't have to work under that supervisor. Well, that employee could come back and say, hey, you know what? I filed a complaint, and in response, the company moved me to the graveyard shift. They retaliate against me. So be very careful. I always recommend, if you do have to make any kind of interim action like that, the person that is being accused should be the one that is, transferred, moved, or even put on an administrative leave until the investigation is concluded. So it comes time to get to the evidence gathering phase of your investigation. It's important to determine what the scope of the investigation is. In other words, we're not just out there on the fishing expedition trying to see what we can find, If somebody made an allegation that this person made, inappropriate comments against me and they touched me inappropriately, that's what we're going to be looking at. We're not going to be looking at, finding as many character flaws as we can this person. We're going to focus on the allegations in this case. So it's also when it comes to gathering evidence too, we also have to look to see what policies this violates and get the relevant documents for it, whether it's, handbooks, policies, that sort of thing. We want to make sure we pull those out, and then we pull out the acknowledgement from both the person making the allegation and the person being accused of uh, doing whatever they did. Of course, any other information you can have, whether it's pictures, videos, if you have security cameras, phone calls, emails, text, computer files, that sort of thing, right? If any kind of those communications took place on your company equipment, there shouldn't really be an expectation of privacy by the employee. You should be able to look into those. But again, make sure that you have that in your policy, right? Make sure that, employees are aware of that. Let them know what their expectation of privacy should be. So when it comes time to prepare for that interview, we got to think about all the W's. So anytime, for each of the allegations made, who, what, when, where, and why. Who did it? What happened? When did it happen? Where did it happen? Why do you think it happened? Again, so, we're not going to walk into that interview with a preconceived notion of what happened. Our investigation, our interview is a fact-finding mission for us. We're trying to find out what happened, not trying to confirm that something happened. So we're just gathering the facts at that point. And as we go along too, as we're asking these questions, we're checking for the credibility of the person that we're talking to. And we'll talk about some tools you can use for that here in a minute. So once you have your interview outline, again, we're going to start making our list of witnesses. Who do we need to talk to in this case? And this is, pretty straightforward. The first one is the person that made the complaint. If they made the complaint in writing or just in passing, we want to follow up with them, get more details, get those W questions answered, right? Who, when, where, how, what, why. We want to talk to the accused. Remember, FIHA tells us we have to give that person a chance to respond to those allegations. And any witnesses that are brought up, whether the complainant lets you know that, so and so was around, or if they didn't mention it, you can always look to see who was working with them in that shift if you want to get some more clarification on it, right? Talk to their supervisor, talk to their coworkers, talk to, maybe the person that's in the cubicle next to them, whatever it is. We, we're going to go either by the list of witnesses they give us, or we can dig into a little more to see who we can talk to get some more information on that. Again, we talked about those relevant documents, relevant information, and during the course of your interviews or conversations with the complainant and the accused, they may bring up other people that they think you should talk to, right? They may have not mentioned who was there in the beginning, but when you're talking to the complainant, they could say, "Oh, well, I was sitting next to so and so when it happened. Now we got to talk to so and so." Same thing when we're talking to the accused, that they're telling you, "Well, that's not how it happened. My friend was sitting right next to me when it happened." Let's talk to the friend. Let's talk to them. And thing about that is, as an investigator, you are going to be the one that's going to determine who you need to talk to and who you don't. So, for instance, you may be talking to the complainant, and they could bring up something like, "Oh, well, so and so told me that they, did that they behave like this outside of work." Is that something that's necessary for us to follow up on? I don't know. It might not be, right? Or, hey, so and so told me that, this person stole creamer from the lunchroom, and you're talking about a harassment complaint. Well, in this case, I mean, there may be no value or no need to talk to that person. So, make those assessments as you go along when different people are brought up. Again, you're not obligated to interview every witness that they name. So just, the ones you need to get those facts. It's very important too when we're talking to our complainants, when we're talking to our witnesses, to everybody, to let them know that we can't guarantee 100% confidentiality and privacy on this, right? We're going to keep this information as confidential and private as possible. However, we may need to share that information on a need to know basis. So again, sometimes a complainant comes to us and says, "Hey, this happened. I want to complain about it, but I don't want them to know it's me." Well, we could tell them we're not going to name you personally. However, you know, the person does have a right to respond, and in sharing the accusation with them, they may be able to deduce that you were the person that made the accusation. So again, we cannot guarantee 100% confidentiality on it. And something else that happens too is sometimes at the end of an investigation, the complainant always comes back and wants to know, hey, well, was the person punished? What did you do? What's going to happen to them? It's important to remember those disciplinary actions that the company takes are also confidential. We don't have to share those with the complainant or with anybody else in the organization. So you can say, suffice to say, we addressed it based on our company policy. You know, we any kind of disciplinary action was taken based on our policy. That's all you need to know. Is that enough? Not always, but again, we have to maintain that confidentiality and privacy. Now, when it comes time to those interview questions, it's important to have some kind of an outline, not a script, but just kind of an outline of things that we want to hit, specific points that we want to hit when we're talking to somebody. And again, as we're conducting this interview, sometimes it's going to take us in directions that we couldn't anticipate. So be flexible, be able to pivot whenever it's necessary. And when you're conducting that interview, first thing to do is you're going to start with some conversational questions, right? Oh, how long have you worked here? What department are you in? Do you like it? That sort of thing, just to kind of get a baseline of the employee's answers, right? And as you go along, then you're going to get into those tougher questions as well. So I have some examples for you, for the complainant who committed the alleged harassment in the case of a harassment complaint, what occurred, when, who had relevant information, et cetera, et cetera. So again, those W questions are so important. And again, we're going to give the person that's accused a chance to respond. Now, these are mandatory questions by the EEOC that we should ask the accused whenever there's some kind of allegation against them. So obviously, we're going to ask them for the response to the allegation, right? We're going to present with the allegations and give them a chance to respond to them. Okay. If they say, well, no, that's not true, that didn't happen, we can ask, well, if someone were to say that it happened, do you know why they would say it? So in other words, if they say, well, that's a lie, I never did that, say, well, why would the person lie about it? Do you have any reason why they would lie about it? Oh, well, it's because, last quarter I got the promotion, they didn't. Okay. That could be a relevant point in this case. So, and again, we're going to ask them for any relevant information, anything they want to add that could shed some more light on the situation. When it comes to witnesses, those third parties that may have seen it, again, those W questions. What did they see? What did they hear? When did it happen? Describe the behavior towards the complainant and others in the workplace. At that time, before it, after it, does everything track? If they were told that something happened with a complainant, so they're there to talk about something they heard from the person complaining, find out exactly what the complainant told them, when it happened, and if there's other people with that information as well. Now, as far as conducting these interviews, it's very important to work diligently to make sure that we are scheduling them in a way that's very quick after the allegations are made or as soon as possible and in a good location for it, right? So in other words, you're going to work with either HR or their supervisors to find out their availability and to schedule those as soon as practicable. So you don't have to tell the supervisors why you need to talk to the person if you're investigating it. And we don't want to give people a heads up as to why we're talking to them or that we're talking to them, because we want to get their real reaction, right? We want to get their honest reaction to these questions, to these allegations, to what happened. Basically, we don't want to give people a chance to gather together and get their story straight, if you will, or what have you. Because I mean, people are going to talk about this, right? People are going to talk about things. As soon as you interview the first person, that word's going to start getting out, possibly about what you're talking about. So again, just we're not going to give people advance notice, and that's why it's so important to conduct these investigations in a timely manner. Because you can start interviewing people, one after the other, boom, 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 without giving them that opportunity to commiserate about it and to coordinate their answers, if that's what happens. Okay. Keep in mind too, I saw this question pop up earlier too. What happens if we have to call somebody that's off of work for an investigation? The investigation is compensable time. So if you have to call somebody that's off duty, you have to call them at home or what have you, that is compensable time if they're not exempt. So make sure that we are compensating them for that time. Now, just as important as making sure that things are timely is the location of the interview. So again, we want to make sure that, it's in a private closed door setting. So if you don't have an office, if you're in the cubicle and you're the one conducting the investigation, maybe set aside a meeting room or somebody's office where you can conduct this, where it's, basically we're not going to have all the workers walking by and looking in the window to see what's going on. If you are going to do this via internet, via Zoom or chat meeting or whatever it is, um, make sure that it's in a private location for you and for them. And also, it's very important to ask, is anybody in the room with you, right? Find out that there's, especially if it's a remote one, that there's nobody in the office with them, coaching them along, feeding them their answers or whatever it is. So in many cases, people may refuse to participate in these investigations. They don't want any part of it. They just want to show up and do their work. They want to stay out of trouble, right? Or sometimes even the person that raised the allegation doesn't want to follow up with it. They don't want to do, they don't want to pursue it any further. They just want it all to go away. Well, guess what? At this point, we already know about it. The company knew or should have known about it. We have to follow through with it. So again, we still have to proceed with the investigation. So, we're going to make an attempt to get that person to talk to us, to communicate with us, and we're going to document, our attempts to talk to them. So whether it's trying to call them, trying to schedule an interview, trying to, if they just clam up and don't say anything when you try to talk to them, whatever it is, we're going to make sure we document that, take notes of that, and make sure that that shows up on our report. So, and again, if somebody's not complying, there could be a chance for disciplinary action. However, if the person's the complainant, again, don't take any disciplinary action against them because it could be seen as retaliation. All right. And the thing to keep in mind too is during an investigation, there is no right to representation with the exception of a union rep. So in other words, someone can't bring their personal lawyer to the investigation or to the interview or whatever it is, right? If you're in a union environment, then they can request for their union rep to be there, but they can't bring in their outside legal counsel to be in the interview with them. If you have an anonymous complaint too, I mean, these are a little more difficult, right? Because we don't know the person making the complaint. We don't know who it came from. But again, we're aware that there's an issue going on. So we have to follow through with our investigation all the same. So again, makes it a little more difficult for the investigator, but we still have to follow through and document everything along the way. So some things that we want to say about, to every person that we interview, talk about cooperation, the duty to cooperate, and the reason why you're conducting the investigation. Reaffirm your company's no retaliation policy. Mention that limited confidentiality. In other words, we're going to keep this confidential as possible, but we may have to share some information on each no basis. Talk about the investigation procedure. In other words, how you're going to take notes. If you are recording, if you're making a recording of the interview for note-taking purposes, make sure you make them aware of that. As I mentioned earlier, if it's a video interview, make sure that you're alone in the office and have the person verify that they're alone on their side of things too, that there's nobody in the room. Now, as I mentioned earlier, when you start that interview, we're going to start with some background questions to kind of set the tone to things, right? That's going to let you know how that person answers. So if the person's nervous from the beginning, from the time they walk in and you ask them what their name is and they seem very nervous, then they're probably going to be nervous throughout the interview. As opposed to somebody that comes in and they're very calm and very collected and very smooth during those initial questions. Then when you start asking the more difficult questions, they get a little more jumpy or avoid eye contact or something. That kind of lets you know that, hey, you know what? The way they're answering these important questions goes against the baseline. So they could be hiding something or they could be trying to deceive me in that point. Now, when conducting the interview, again, we got the scope of our investigation, so we're going to try to stay focused on that task at hand. Sometimes a lot of witnesses or other people take this as an opportunity to just air all their grievances. So it's important to kind of keep them between the rails, right? Keep them on the topic at hand. When you're conducting the interview as well, you should only be doing 20% of the talking. The employee should be talking 80% of the time. So we're not filling in any gaps, prompting them, answering questions for them. speculating, that sort of thing. We're basically letting them talk, asking for clarification when necessary, and, trying to be straightforward, right? We're not trying to trick anybody. This isn't Law and Order. We're not trying to get somebody to fall into a trap. We're just trying to get the facts. So it comes time to reach our conclusions after our interviews. The important things to consider is how credible were your witnesses? How credible were the people you talked to? And some things to consider, of course, is inherent plausibility. So what this means is how likely is it that what they said happened? You know, is it likely that that's how things happened, or does it feel a little outlandish, a little bit out of sorts, or that sort of thing? So the other one is the demeanor when you're talking to them. That's what I mentioned. That's why it's important to observe them. Did they get very defensive over certain questions, not others? Were they elusive? Did they not want to talk? That sort of thing. Do they have any reason to lie to you? Again, that could weigh into it. And corroboration. If you talk to 10 witnesses and 9 of them say one thing and one of them says something completely different, I mean, if the other 9 corroborated all their information, that may be what really happened. And finally, past record. We're looking at the past record both of the complainant and of the person, the accused, because that could play a part in it. So again, we're looking at all of that information to see, why those answers were what they were. Some things to look for, when the person's talking to you, see if they're trying to deceive you. Again, if they nod or shake their head in the manner inconsistent with the answer they're giving, remember when you're communicating with somebody, the words coming out of their mouth are only maybe what 20 to 25% of their true communication. The rest is all body language. So we're looking at that body language. Are they sweating profusely? Are they blushing with certain questions? Do they start trembling, gulping, or finding it hard to swallow? Do they cover their mouth when they answer certain things? That could be a sign that they're lying or that they're being deceptive. Any fidgeting, or if they try to place things, between you and them when you ask certain questions, building, if you will, almost like a barrier between you. All those things are important to observe and take notes of during your interview because they could be giving away more information than they really think by their body language. So it comes time to reach our conclusion or a determination based on our investigations and our assessment of what we heard. We're not looking for the answer beyond the shadow of a doubt. Again, this isn't court. You know, we're just looking to see, is it likely that something happened? Is it likely that it's true? So again, we're not looking for something beyond a reasonable doubt. And what the Civil Rights Department tells us is you're looking for 50% plus a feather. So if it's likely that something happened, slightly likely, more likely to happen than it did not, chances are that's the way it's going to go. So, and again, our conclusion is going to be based on the evidence. So when we're preparing our written report of the investigation, this is the not so fun part unless you like writing. So we're going to summarize the investigation as a whole. We're going to summarize the allegations, the interviews, any information we gathered from them, any documents that we used for the investigation, policies, handbooks, video evidence, that sort of thing. We're going to make a note of all that in the investigation report. And again, our conclusion is going to be based on the facts. We're not lawyers. We're not from the state here. We're not looking for, violations of the law. We're looking for policy violations, and the facts and which way the facts point us. Again, so, we're being objective and factual in our conclusions. The report itself is confidential. So it's not something you're going to write up the report and stick it in the employee's file or what have you. You got to keep this a separate file. It's only going to be shared on the need to know basis. So if you requested a copy of it by the complainant, the accused, their attorney, whatever it is, consult legal counsel immediately. Again, this is to be kept in a separate file, separate area, not in the employee file. So it's not something that they need to or that they can view anytime they want. It's separate. So if you requested a copy of it, consult legal counsel to see if you should share it or not. And if, as an investigator, you take other notes, you're scribbling notes as you talk or anything, and then you use those to write your final report. It's up to you whether you destroy or keep those notes. We recommend you keep them as part of the report, but it's up to you. Just the important thing with this is to be consistent. So If your process is to destroy those notes, once you're at your report, just make sure you do that every single time. Now, in writing that report, we're going to answer to each of the allegations that were made. Remember, during this determining the scope of the investigation, we're going to determine the things we're going to investigate. So again, each allegation should have its conclusion attached to it. So the conclusion is not going to be, this 100% happened, this is what happened. No, we're going to say this allegation was either founded, or it's more likely than not that this happened, or it was unfounded, more likely than not that it is untrue. Sometimes you can use that inconclusive. You could say there's not enough evidence to determine one way or another. We want to avoid that. Again, that's the whole purpose of finding the facts. So remember, it's 50% plus the weight of a feather. We don't have to be 100% sure that something happened, but if there's enough evidence to point that maybe it happened or that more likely than not it happened, that is what we are going to write in our conclusion. And just as importantly too, if any corrective action is necessary to address what happened, make sure you do it in a timely manner. Don't wait until after Christmas because you don't want to ruin somebody's Christmas. Don't wait until it's review season. Do it immediately if there's policy violations. And especially if it's some kind of harassment, discrimination, retaliation complaint. Again, and we're going to look at our policy. We're going to look at our practice. We're going to stay consistent with it. Look, see how many violations there could be now. Whatever corrective action you take, that's going to be dictated by your policies and procedures. What's your company's corrective action process? And if the findings, when you come up with your report, you find that there was discrimination, harassment, or retaliation involved, we recommend you consult legal counsel before moving forward to address any exposure you or the company have when moving forward. So some takeaways for you. I know it's a lot of information. This was a huge presentation to take in, so hopefully, I didn't ruin your lunch today. Things to take away with you: pay attention. Pay attention to what's going on in the workplace and pay attention to those triggers for an investigation. Always be prompt in your response. Don't put it off until next week or next year or next quarter, whatever it is. Be very meticulous when you're selecting the person that is going to be conducting the investigation. Should it be internal, external? Who should it be? Documentation. If anything management or HR related, documentation is so important. So we're going to document and summarize our findings. If we have to take corrective action, make sure it's meaningful and consistent with our policies and our practices. And finally, follow up so it doesn't happen again. Once you conclude an investigation, once you take corrective action, follow up with the complainant, follow up with the accused, just to make sure things are moving along and the issue was addressed. So for those of you that are with us for continuing education, I do have some codes for you. We have 670-418 for HRCI. And if you are in the continuing education for SHRM, it's 24-3EEVF. Please do not forget to throw that dash in there. SHRM throws it in there, so we have to throw it in there as well. I'd like to remind you too, we have the hotline for Ventura County, 888-763-3174. Give us a call. We'd love to hear from you. We'd love to help you with any issue. Or if you want to call us up and just need someone to hear about what's going on in your workforce and not sure if you should react, give us a call too. We'd love to hear about those sort of things. If you would like, or you're interested in any kind of membership with CEA, we do offer different tiers or different levels of membership there, including a $109 monthly membership for you. And I know Anna mentioned early on that we had a survey for you. So just as promised, here is the link for it. I think she'll drop it in the chat as well, like she tends to do. Let us know what you liked about the presentation, what you didn't, and what you would like to hear about. If there's any topics that you want to learn more about or you want us to talk to you about or whatever, let us know. With that, I'll turn it over to Anna now that I stole all her lines that she uses to wrap up.
I was going to say, I pretty much think you covered it. I think the only thing left to say, two things. One is over in the chat box, I did drop the link to the next training that's coming up in July on the 25th. And it's, of course, sponsored by Ventura County. It's a free webinar. And that's our 2024 mid-year labor law update. So that's also a very popular one. It's going to be full of a lot of information. So I really encourage you to sign up for that. And And just another thank you to Rebecca, Colleen, Cynthia, the entire team behind the scenes over at Ventura County Workforce Development Board for sponsoring today and gathering all you amazing people here. Thank you, Eli, for delivering so much content in less than 60 minutes, and Juliana in the chat for making sure everyone got their questions answered. You do have the PDFs if you need to refer back to that hotline number. I really encourage you to utilize that hotline, and we'll see you on the next training in July. Thank you all.